Good morning, Lena.
Good morning.
Looks like you're going to have an exclusive lecture today.
Yep, that works for me.
Yeah. Okay. Before I resume, did you have any questions, comments, or suggestions arising from last time or generally?
Not really. I wasn't really too confident about the banker's lien, to be honest.
Right. Okay. I've just started the lien, haven't I? So we can go over that a bit. So, here's Brock. Welcome, Brock and Beck. I was just saying to Lena she was about to have an exclusive lecture, but I'm glad you guys have arrived. Let's share screen. Nope, no, that's not the right one. Stop, hang on, I can. Can you see that, Lena?
Yes.
Banker's lien?
Yep, can see.
That's good. So I'm struggling a bit with the going back and forth between, let's have a reading between, hang on. Is that the one we're up to? Yeah, that's number 4. So I'd got to this one. So is the particular issue the concept of a lien, or was there some other aspect that you were unsure about?
Yeah, just a general concept like the defense against torts of detinue and conversion.
Yeah.
And the example that about the bond.
Yeah. Okay. So if you think back to the beginning of the course when I talked to you about the concept of possession on the one hand and property on the other, what is possession? It's an exclusive right to use and abuse a chattel. So because it's exclusive, only one person can have the right. So anyone else is prohibited from using or abusing the chattel. And there's also a right not to be deprived of possession. So it's a civil wrong to use it without permission. It's a civil wrong to abuse it without permission. It's a civil wrong to take possession of the chattel without the permission of the person currently in possession of it. So you get the sense that possession is a collection of legal rights constituting or correlative to legal duties. Now, compare that to property. Property is what you have when somebody else has possession of a chattel. So if, for example, I lend you my car, you have possession of the car, and I have the right that you reconfer possession in the future. It might be when I make demand, I say to you, Lena, give me my car back. That operates to vest the duty to reconfer possession. Or it might be that I've lent you the car for 7 days. And so after the passage of 7 days, then you have an accrued duty to reconfer possession upon me. So during the time that you have possession of the car, I don't have possession because possession's exclusive. I have the property, okay, the property being the right to possession. Now, if you have a lien, that confers on you a right to withhold possession until such time as some other duty has been performed, namely the payment of a debt. So the lien operates to defeat or operates as a defence to a claim in detinue for recovery of possession. So if I say to you, I want possession of my car, and there can be liens over cars, they're not bankers' liens, but there can be a lien over a car. So I make demand on you, and you say, no, you need to pay me the money you owe me for me fixing your car. And you're entitled to retain possession so that if I were to sue you and detinue for recovery of possession, the court would say, no, Mr. Dempster, you need to pay Lena the money you owe her for working on the car. Okay, so the lien operates as a defence to a claim in the law of torts for debt anew. Does that answer your question about the meaning of a lien?
Yeah, I think that made it clearer. Thank you.
Yeah, good. All right. So I think we got to this slide last time, and the second bullet point is there's no lien over money in an account. And actually, that's because there's no money in an account. That's because an account is a contingent debtor-creditor relationship. It's not a pile of physical money. So there is a right of combination, which I'll get to hopefully later today. So bearing those propositions in mind, C attends the branch of his bank to draw on his account, which is in funds. The bank refuses to pay on C's demand because C is in default on his mortgage payments. So he's procured a loan from the bank, which is secured by a mortgage over his house. And the choice you have is that the bank is entitled to refuse to pay C's demand because of its lien, or the bank's entitled to refuse to pay C's demand because the bank has added C's current account to his loan account and he has no funds available. Well, this one, I'm just going to answer this myself. This one is actually testing the second bullet point here. There's no lien over money in an account because there is no money. So A must be wrong. So that means B must be right. And I've in a sense, I'm anticipating material. I'll come back to this in due course. But what we're talking about here is not the banker's lien, but rather the bank's right of combination. Okay, the banks have a right to combine accounts to reduce the overall level of indebtedness, subject to certain exceptions. So B is the right answer. In a sense, I'm anticipating material, so you might be slightly puzzled. But the clue is that A must be wrong because it's testing the second bullet point here. There's no lien over money in an account. Okay, so that tells you that A must be wrong. Any questions on that example?
I got a short question.
Yep.
Does the account mean the current account?
Yeah.
That's
the transactional account. Yeah, it's the current account. Yeah. All right. Now, I said to you that in response to your specific question, Lena, about the lien being a defence to a claim in tort for debt anew and potentially conversion. In addition, there's an additional right, and it's an unusual right because generally speaking, liens do not confer the right to sell the collateral. They are under the common law, under the general law, they're just a right to withhold possession. Of course, Parliament has, by statute, created a right to sell the collateral on default. But there's no such right under the general law, but there was an exception, and the exception is the banker's lien under the common law, which common law came out of the mercantile law. So from the merchants' courts into the royal courts of common law, the banker's lien does confer the right to sell a security. What is a security? Well, it includes negotiable instruments, which is the next topic. So when can you sell? If a fixed time for repayment has been nominated and the payment hasn't occurred, or if no time is fixed after a request for repayment has been made and reasonable notice of an intention to sell has been given. Okay, so yeah. Now, the right of sale probably is restricted to securities that pass by delivery. or by some other method that may be exercised by the bank through its own means. So if a transfer requires the cooperation of the customer, probably the bank doesn't have the right to sell the collateral in that context. So it's got to be something that only that the bank alone is able to do. Okay, so that means it's probably limited to bearer securities. I haven't yet taught you about bearer negotiable instruments, but I will do presently. And practically speaking, the right to sell collateral where the collateral is bills, notes, and checks, probably not much practical importance, because when a bank collects on the customer's account, the bank also has a right to combine. And so practically speaking, it may not be that significant. It will be significant practically where the bank is not acting as a collecting agent. It just happens to have possession of them. It may be practically significant there. But I mean, also there's the issue that in general, negotiable instruments are becoming less important in the context of banking because of the use of the online payments through the payment system, which we'll get to in due course. Any questions on that slide? All right, bearing those in mind, C leaves her passport at the bank to identify herself. C attends the branch and demands the passport back. The bank refuses because she is overdue on a loan account, and the bank sells the passport. The choice here is that the bank acted lawfully because the lien confers the right to sell. Alternatively, the bank has converted the passport by selling it. What do you think about this? Would anyone like to offer an answer here?
Would that be about the first bullet point about the reasonable notice of intention to sell, and that was not given?
That's a good thought, Lena, but no, it's thank you for that, but it's to do with the nature of the collateral. And the point that the right of sale may be restricted to securities that pass by delivery or by some other means. Passport's not a security. I'll just check. I just see there's a. Beck says B. Yes, I agree with Beck. Yeah. There's a further technical point here, which is that if you look if you have a New Zealand passport or a British passport, at least, I don't know about other passports. Lena, you might have a passport from the continent, but under the British Crown and the New Zealand Crown, passports remain the property of the Crown, the government, or the Crown, technically speaking. We have possession of it, but property remains in the Crown, and it's stated in the passport. And so certainly you have no right to sell a passport. That's actually not only the tort of conversion, probably an illegal contract. There is a quite significant black market in passports, particularly British passports, but also New Zealand passports. So yeah, no, it's definitely, there's no right. The banker's lien confers no right to sell a passport. It's not a security, and it's not something where ownership could be transferred by the bank alone. The Crown would have to approve the sale, which it would never do. So B is the right answer. Any questions on that slide? All right, moving right along. Right, we're moving now to the right of combination. So we've moved from the lien, we're talking now about the right of combination. Absent an express or implied exclusion by contract. So it's another one of these rights that the law itself confers, but the right can be excluded expressly or implicitly by contract. So absent an express or implied exclusion, a bank may combine customers' accounts and treat the balance as a single amount either due to the customer or the bank, depending on whether the balance of liabilities lies or balance of liability lies, including when kept at different branches of the same bank. I mean, that's what the law says. I think the whole branch structure of banking law is going to disappear if it ever comes back before the courts. But when you look in the commentaries, they all use the expression the branch. But as I say, I think the courts will not uphold those distinctions. Sometimes you'll see this right described as the banker's right of set-off. It is not a right of set-off. As I explained to you in the first a couple of lectures, the right of set-off is a procedural right. It only exists when you're in front of a court. I also explained that the fact that there is such a right of set-off provides a background pursuant to which people will contractually agree to set off debts. But the banker's right of combination is an out-of-court right. It's a substantive right. So the right operates on substantive rights and obligations. So it's quite different from the procedural right of set-off. Notwithstanding that, you'll frequently see in the commentaries the use of the expression, the banker's right of set-off. I'm sorry, some of the commentators don't know their concepts very well. Importantly, the bank has no duty to notify the customer before combining accounts. It can just choose to do so. Any questions on that slide? A simple example, a C holds a current account and a loan account and keeps the current account in funds by payments. C draws on the current account. The bank combines the loan account with the current account and dishonors a withdrawal. The choice you have is that the bank has breached its contract with C. The bank has not breached its contract with C. This is a slightly a trick question. I'm just going to answer it myself to keep things moving. So the bank has breached its contract with the customer. It is thought that a loan account is an express or more likely an implicit exclusion of the right of combination. Okay, so here we have a current account and a loan account, and the bank has purported to combine the two accounts to produce a single balance and uses that single balance as a justification for dishonoring a withdrawal. But the law says that a loan account is an implicit exclusion of the right of combination. So the bank has no right of combination in this context, and therefore it can't dishonor the withdrawal demand made upon it by C. So A is the right answer. Now, you might think, okay, well, I understand that, but Hamish said earlier, in this example, that B is the right answer. And that's true, I did. So those of you who are alert this morning, you've had your cup of coffee already, you might say, well, those two things don't seem consistent. They are consistent. The distinction is that in this case, it's a secured loan. In this case, it's an unsecured loan. So if there's a secured loan, the loan account is not thought to implicitly exclude the right of combination because there is a specific security granted by the customer, namely the mortgage, which the customer has granted to the bank over the house. And the bank needs to look to that security for the purposes of recovering its costs. So therefore, there's no exclusion of the right of combination. So that's By contrast, here, it's an unsecured loan, and the unsecured nature of the loan is thought to implicitly exclude the right of combination. Okay, any questions on that example? All right, now, the mere fact that a customer has opened a second account does not amount to an implied agreement by the bank to keep the account separate. For example, if there are two current accounts, that's not an implied exclusion of the right of combination. In fact, there would be no right of combination if the mere fact of opening a second account were thought to impliedly exclude the right of combination. However, an implied agreement to keep the account separate will ordinarily be found if one account is a loan account, and that's precisely this example here. So this example is anticipating this. That's why it's sort of partly a trick question. Secondly, if money is paid into an account for a special purpose known by the bank, the right of combination with other accounts is precluded. So a customer can say to the bank, I'm paying this money into the account for this particular purpose. Unless the bank objects, that special purpose operates to exclude the right of combination. Any questions on that slide? Right, there's no right to combine accounts if one of them is a trust account. Exception, if the beneficiary of the trust is independently a debtor of the bank. In that case, there's what's called an equitable set-off. But again, that's what the commentaries say. It's called a right of equitable set-off, but it's really an equitable right of combination. It's not a set-off. It's an equitable right of combination. However, for this to be true, the circumstances must be such that the court would, without further inquiry, order a transfer of the account to the equitable owner, to the beneficial owner. In other words, there must be a bare trust. A bare trust is a trust where the only obligation is the obligation of the trustee to transfer legal ownership on demand. There are no other obligations. Okay, so bearing those two propositions in mind, simple example, T is a trustee for B and in that capacity holds funds in an account at C Bank in which he deposits income earned as a trustee and out of which he makes payments to the beneficiaries of the trust. B is a gambler, so one of the beneficiaries is a gambler and owes the bank a large sum of money on a loan account. The choice you have is that the C Bank may set off T's account against B's account. The bank may not set off T's account against B's account. Again, I've put set off in quote marks because we're talking about a right of combination, not a right of set off. Rights of set off are procedural. They only occur in civil proceedings. We're talking here about a substantive right out of court to offset, to combine accounts to produce a single balance. Okay, that's why I've put quote marks around the set off. Anyway, which is the answer, A or B? Would anyone like to offer an answer here? I think we have a, Beck suggests B, and I agree with Beck. Would you like to offer a reason, Beck? You don't have to. I run these on a consensual basis, but be pleased to hear from you if you want to have a go. Is it due to the bare trust point? Yes, well done, very, very well done. What's the key fact here, Beck? Key fact is that the trust has beneficiaries, of which B is one beneficiary. So unless all of the other beneficiaries agree to the assignment of the beneficial interest, it's not a bare trust. So it's insufficient for B to transfer the beneficial ownership. They all have to do it. So it's not a bare trust. So Beck's exactly right. Well done. Any questions on that slide? Okay, we're making good progress. Appropriation of payments. So I think this is the last of the general law concepts. Appropriation of payments is difficult to understand in the sense that the explanation for the concept is difficult. What I suggest to you is that you learn the rule and don't worry so much about the reason for it. I will attempt to explain the reason for it when I talk about payment systems, but in the first instance, just focus on learning the rule and just artificially apply the rule. Don't think about the reason for the rule. Just ask yourself, what is the rule, and apply it. So what is the rule? Absent evidence of an intention, contrary intention, or an agreement, every amount paid into a current account goes to discharge the earliest debit item in the account. It's called the rule in Clayton's case. Clayton's case is a case from the early 19th century. It's also known as Clayton against Devane and Noble. Very, very famous case. I don't want you to go and read it. The case is enormous. It goes on for it's ridiculous. So it's not very effective and efficient. So just for the purposes of calculating the current balance, so every amount paid in goes to discharge the earliest debit item in the account. That's how you work out the current balance. So if a person keeps a running account, and that's what a current account is, it's a running account, it will be concluded payments have been appropriated according to Clayton's case, or the rule in Clayton's case, and you can't later seek to vary the appropriation. And the rule is not displaced merely because it would be to the advantage of the person receiving the payment. All right, so bearing that in mind, this is the actual facts of Clayton's case itself. So Clayton's account is with Devane and Noble and Co. So it's a banking partnership. This is the days before the joint stock company. So most businesses were partnerships then. So Devane and Noble is a firm showing a balance of £1,717. Quite a large amount of money. If you think about what I told you about the balance in Joachimson's case, that was £2,321, I think. Here we're talking about £1,700 a century earlier, so even more value. Devane dies. That operates to terminate the partnership, and then there's a successor partnership of I've forgotten who he is, but Noble and Co. So it's the surviving partners continue on. They pay to see amounts exceeding 1,700. Oh, sorry, I've got dollar signs. It should be pounds, but no, actually, no. Call it dollars because I've New Zealandized this. $1,717, and then C pays further amounts into his account with E, N, and Co. They break, they go bankrupt. And the executors of Devane are sued by Clayton, demanding $1,717. So Clayton sues Devane's executors, the executors of Devane's will, on the basis that partners are jointly and severally liable, and the thing that the court has to work out is whether or not Devane is liable to Clayton. And in order to do that, they have to apply the rule of appropriation of payments to produce a balance, after which point Devane or Devane's executors owe no money to Clayton. So we know from this that after Devane dies, EN and Co. pay amounts exceeding $1,717, and C is also paying further money into his account. So if you apply the rule, what's the answer? Well, the monies that the surviving partners pay out to Clayton, you apply those, you appropriate those to the payments in. You go back to the earliest one, and that produces a nil balance, and that operates to discharge Devane's executors from any liability to the account holder, so that the further money paid in by Clayton, that's a liability of the surviving partners. It is not a liability of the executors of Devane's estate. So that means B is the right answer. Okay, so you just need to apply the rule. Don't think about the reason for the rule. I'll explain the reason for the rule when I talk to you about the payment system. If you look here, I've put in brackets, the rule in Clayton's case is a rule of convenience. I've done that because the commentaries say this. In my view, the commentaries are wrong. There's a reason for the rule, which I will explain when I talk about the payment system, but I'm sort of in a sense bound to say what the commentaries say, just to give you a sense that there are two views about this. Most people think it's a rule of convenience. I don't. I think it's to do with the nature of account, which I'll explain when I talk to you about the payment system. All right, does anyone have any questions on the example? Do you understand how the rule is applied here? You're nodding, Lena? Yep, okay. All right, if you don't understand it, and some people don't, I've found, feel free to contact me. Happy to talk to you via Zoom or by phone, whichever's, yeah. All right, opening a new account displaces the rule. Hence, if there are two or more accounts, you apply the rule to each account separately. You don't combine them. That's the right of combination. We're talking about the rule of appropriation. And the person depositing money with a bank has the right to say to which account it should be appropriated, okay? You go in and you say, I'm depositing this money into this account. So you have a right to do so. If you don't exercise that right, the person receiving payment may appropriate it. So if you go into the bank and you don't tell the bank which account it goes into, the bank has the right to choose, and then that's binding on the depositor. This is just an application of the right of appropriation on payment. And actually, I think that this is an example where it's the law of money hadn't received applying in this context, but don't worry too much about that. It's not important for your purposes. Just understand the rule that the depositor has a right to appropriate between accounts. If he or she fails to exercise that right, the banker has a right to appropriate it. Sorry, any questions on that slide? All right, money paid in to meet a particular mandate must be applied to that purpose unless the bank refuses to accept the deposit under such conditions. So if, for example, you go into the bank and say, I want to make a payment to a third party by mandate, for example, you direct the bank personally to make a payment through the payment system, and I'm making a deposit for that person, then that operates to disapply the rule in Clayton's case. So the bank has to honour that purpose unless it refuses to accept the deposit on those conditions. The bank can say, no, looking at your account, no, we're not prepared to accept it on that basis. We're concerned about your overdraft. Okay, so the bank has a right to refuse to accept that instruction. When a fiduciary has mixed his or her own money with sums of trust money, a fiduciary includes a trustee. It's not limited to a trustee. But if a fiduciary mixes his or her own money with sums of trust money in a private account, Equity will attribute withdrawals to his private money as far as possible. The idea is to protect an asset to which recourse might be had by the beneficiaries of the fiduciary who has mixed his own money with trust money when he ought not to. If we're not talking about fiduciary relationship, if the funds of two beneficiaries or of a beneficiary and of an innocent volunteer are mixed, then you go back to Clayton's case to determine the respective entitlements. Okay, so Clayton's case applies to the mixing of the funds of two beneficiaries or of a beneficiary and an innocent volunteer. It's only when you get the fiduciary mixing his own private money with the fiduciary money, and the law will not hear the fiduciary say, "Oh, that was the trust money that was paid out." The court will say, "No, we're going to attribute you to have. We're not going to let you avoid the liability to your beneficiary, and we're just going to ignore what you say and attribute that money to you to preserve an asset for the benefit of the beneficiary." Any questions on that slide? All right, I think there's just one. Oh, here's an example of the previous propositions. C's account with B Bank is overdrawn by $1,000. C deposits $2,000 with the bank stating to the teller X, "I need that deposit to cover a mandate for $1,500 I'm ordering." The bank dishonors the mandate. The choice you have is that the bank has breached its contract with A or the bank has acted lawfully. So the issue is whether or not Clayton's case applies, and therefore the balance of funds is insufficient for the mandate, or somehow Clayton's case has been excluded or overridden by an exception. Would anyone like to have a go at this one? The answer is A, the bank has breached its contract with the customer. Oh, I'm sorry. There's a typo there. That should be C. No, I will fix that. That should not be A. It should be C. I beg your pardon. I just need to make a note of that. Slide 17. Okay. The customer has appropriated the payment. I need that deposit to cover a mandate for $1,500 I'm ordering. The bank says nothing. The bank can say, no, we're not accepting that appropriation of this payment. So if you go ahead and deposit us, then Clayton's case will apply. They won't say that, but they'll say that will mean that your balance is $500, and therefore you have insufficient funds for a mandate. But it didn't do that. It just accepted the deposit with that appropriation. That means that the appropriation by the customer overrides the rule in Clayton's case, and there is sufficient funds for the mandate of $1,500 because that's a $2,000 deposit. So the court, a court will say the bank has acted unlawfully by dishonouring the mandate. It's breach of contract, possibly also defamation for reasons which I explained earlier in the course. Okay, so it's testing, it's testing that first proposition on the previous page, okay? Any questions on that example?
Yes, so the bank could have just avoided it by saying no.
Yeah. So what the teller should have done, they should look at the balance and see that there's $1,000 overdrawn, and unless the bank wants to accept that appropriation, it should say no. We're not going to honour this mandate, given your current overdrawn status, and that then puts the choice back with the customer whether to go ahead with the deposit or not. So yeah, okay. All right, any other questions generally on general law concept before I start into okay, can you see that? Negotiable instruments. Yeah? Yeah, cool. Okay, now, as discussed at the beginning, thanks, Brock. Yep, thanks. Or is that Beck? Sorry, Beck, that's Beck. Because of the banks no longer issuing and collecting on domestic checks becoming much less significant in practice, they're still collecting on foreign checks. For example, ANZ is still collecting on checks drawn on Anglophone banks, Canada, Australia, US, UK. So that, you know, if it were just foreign checks, I probably wouldn't teach this material. The issue is though that there's quite a few promissory notes that still apply in the banking system, and so you do need to have a sense of negotiable instruments in the meantime. So hence this material. Unfortunately, the way that the Bills of Exchange Act goes, it sets out all the rules for bills of exchange and then just applies them to promissory notes. So I have to teach you bills of exchange and then explain how they apply to promissory notes. So I will post on Blackboard the Bills of Exchange Act, but it's, you know, you can just find it in Legislation NZ, Bills of Exchange Act 1908, but I will post it on Blackboard in the course content folder. Section 3 sets out the definition of a bill of exchange. It's an unconditional order. in writing. So these are always, that's what an instrument is. It's a written document with legal effect. That's what an instrument means. Written document with legal effect. Something can be in writing and evidence something, but that's not an instrument. It's the writing itself is the legal effect. That's what an instrument is. If the writing just evidences a legal effect, that's a slightly different concept. So that's what an instrument is, and we're talking about negotiable instruments. I'll explain what negotiable means a bit later. So it's an unconditional order in writing addressed by one person to another person and signed by the person giving it. Okay, so the person giving the order must sign it to indicate their identity and the fact that they are giving the order. And what does the order do? It requires the person to whom it is addressed to pay on demand or at a fixed or determinable future time a certain sum of money to a specified person or to the order of a specified person or to the bearer. The words to the order of a specified person or to the bearer relate to how you transfer ownership of the instrument. Okay, that goes to how it is that you make somebody else, somebody other than the named payee, the owner. Okay, but that's your definition. So I've got an example here. This is not a bill of exchange because it hasn't been filled out. But if you were to fill it out, there's the date. That's the identity of the person making the bill of exchange. That's the person called the drawer, because they draw the bill on somebody else. That's the drawee. There's your order. It's the word pay. The word order there is not related to the order to pay. It's to do with the way in which the ownership is transferred. That's this point at the bottom. So there's two, the word order appears twice. So that's potentially confusing. That's the word pay is the order that I'm talking about here. It's in the what's called the imperative voice. It's when you instruct somebody, place an obligation or duty upon them, you use the imperative voice. Do it. So that word pay is in the imperative. That's your order. And then after the word pay is the name of the payee. That's the person to be paid. And underneath that is the checking, savings, investment bank. That's the drawee, the person to whom the order is given. Okay, so an unconditional order in writing addressed by one person to another person. Okay, the one person is John Adams, the other person is Checking Savings Bank. So John Adams is ordering Checking Savings Bank to pay a named payee. So you would include the payee in that first long line there after pay to the order of. As I say, bills of exchange are either payable to a payee or to bearer, or to a payee or to order. This is an order bill, pay to the order of the named payee. So it's an order, and I'll explain the significance of that. You write the amount in numerals there, and then you write the words in writing. And if there's any discrepancy between the two, which takes priority? Anyone think which might take priority, words or numbers? It's words. If there's a discrepancy between words and numerals, it's words that take priority. Bottom right, there is a place for signing it. That's your signed by the person giving it, so that goes bottom right. The words on the bottom left for, that's just for convenience to explain what the payment is for. It's not part of the definition of a bill of exchange. Okay, so that's very simple, legal instrument. Any questions to that point? All right, simple example. A signs a document notifying its banker that it hereby transfers its right to payment of the amount of funds standing to its account to B. This instrument is a bill of exchange. This instrument is not a bill of exchange. It is an instrument. It's an assignment under the Property Law Act. It is not a bill of exchange. It's an assignment. It's transferring an existing right to payment under the Property Law Act. You don't need to go and read the Property Law Act. Just understand that you can transfer an existing debt, including contingent debt comprising funds in an account, by an assignment under the Property Law Act. It is not a bill of exchange. I can see it is 20 past, so I must stop at that point. Does anyone have any questions to that point? All right. Thank you, everyone. I will see you all on Wednesday morning, hopefully.
Thank you very much.
Thank you.
Cheers. Cheers. Thanks, Beck. Thanks, Brock. All the best. Cheers.